put a request? Is it okay?
Yeah, we had to record that.
Okay,
Yeah.
okay. So coming back to this topic, and why we chose this topic, and also what is the genesis behind this topic. This, as you can understand, is not topic of Income Tax Act, search survey, or maybe PMLA provisions of arrest and seizure and all this stuff. This is a bit of a different topic, and the genesis of this topic lies in an interaction I was having with my friend Prashant, and we were thinking of the differences between the procedures of PMLA and the Income Tax Act, and at the end of the day, they do both serve a similar purpose, which is cleaning the money. The laundry, the money laundry in which the money is cleaned. But at the end, and there's a difference in procedures, and also there is a difference in the powers of the authorities, which are like vastly different. And also because of the fact that the PMLA is a very recent promulgation in 2002, whereas the Income Tax Act has a very checkered history since 1961. And although we might be aware that there have been some talks of the direct tax code and everything coming in, but that is still something in the making, not coming. So since 2000, there has been an amendment in the PMLA in 2013. That amendment has actually, made it more sacrosanct in terms of enforcement of its provisions. The basic problem out here is black money. Is my slide visible right now? Is my slide visible? Hello?
Yes, it is visible.
Hello? It is visible, right? Okay. So, see, the problem is black money. This is the core of the problem. This is the heart of the problem. I believe
Can I
there's a child
request the child to mute, please? जिसका बच्चा है, please आप mute करिएगा.
टूरिस्ट प्लेस होगी ना.
Hello.
जी आप अपनी तरफ से है ना इनको म्यूट कर सकते हैं. यू आर होस्ट नाउ.
How? Okay, I am. How do I get? Okay, 1 plus 6, 8. Okay, there are people out here, and okay, now it's muted. I guess. I'm sorry. So can we start again? And my screen is visible.
Yeah,
Yes,
you're
yes.
audible and visible. Yes.
Okay, so now so the problem is black money. The problem is black money, and black money as a concept is something that strikes at the very root of an economy, at the very root of a society, in ways we cannot imagine. For example, when we speak about the black money, the first thing that comes to our mind is it proliferates and helps us in illegal activities like bribery or smuggling, drug trafficking, human trafficking, illegal arms dealing, all the stuff, corruption, definitely, political corruption, administrative corruption. So that is one thing that comes to our mind. The other thing, those are obviously the direct consequences of black money, but there are also indirect consequences. For example, a country loses revenue, a jurisdiction loses revenue. As a result of losing revenue, the development of the country suffers. Now, if we are aware of the situation, if we go to these countries, the African countries, or maybe the South Asian countries, which are not so developed, and we know how rampant corruption is out there. For example, if we go to Ivory Coast in Africa, or if we go to Senegal, or if we go to any of those countries are very underdeveloped and malnutrition. There's a lot of stuff is there. That all originates from black money. Because of black money, the government of those places does not have enough resources to provide for healthcare. I mean, we all can agree to a fact. I don't think we should be having any confusion, but uh, we did have a very good immunization with the COVID system, the COVID during the COVID period, the COVID injections and everything. We did have one of the best programs in the world. I think we can all agree to that. Yes.
Yes, yes.
It was possible because we had monetary resources to implement it. Now, unless and until you have monetary resources, those things don't happen. Black money is at the heart, striking at the heart of those monetary resources. And another thing which happens is it stifles innovation. Because अगर आपकी ब्लैक मनी है आपके सिस्टम में एंड आपको ग्रांट्स नहीं मिल रहे हैं आपकी यूनिवर्सिटीज को टू रिसर्च एंड अगर आपके बिजनेस चैम्बर्स को बिजनेस प्रमोट करने के लिए ग्रांट्स नहीं मिल रहे हैं गवर्नमेंट से या कहीं से भी, सो दैट ऑल्सो इज because of the influx of the black money in the system and avoidance of taxes, competition खराब होता है. ठीक है, legitimate businesses हैं, these legitimate businesses suffer because what happens is एक लेजिटिमेट बिजनेस है, फॉर एग्जांपल एक जीएसटी दे रहा है अपना, दूसरा एक बिजनेस है जो जीएसटी नहीं दे रहा है, कुछ भी नहीं दे रहा है, कुछ नहीं, अपना बिजनेस किया जा रहा है, सफर्स बिकॉज जिसने जीएसटी देना है उसने आपको सर्टेन मार्कअप करके देना पड़ेगा. So your goods are definitely, or your services are definitely going to be more expensive from people who are actually into the system rather than those people who are not there. But this person who is actually a law-abiding citizen and maybe, striving for a betterment of the country, betterment of the business, might suffer because of black money that's been generated from out of the system. These are just some things that happen. The main thing behind promulgation of the PMLA. PMLA was incorporated in 2002 and was amended in 2013. So the basic theme behind PMLA was it was designed to stop quote unquote criminals from taking unfair advantage of the system. And the PMLA Act has basically defined, characterized, defined would be a wrong word, characterized money laundering into three stages, three primary stages. Placement, which is introducing dirty money into the financial system, moving money through complex transactions to hide its origin, and integration, reintroducing laundered money into the legitimate economy. So there is illegitimate money which is coming from certain sources, which needs to be legitimized. So it generally layers through a complex web of financial transactions, maybe a layer of 15, 20 companies or something like that, or maybe trusts, or maybe tax-free jurisdictions, and then it is moved ahead and then reintroduced into the economy out there. All through possibly saving taxes or possibly targeting some transactions which cannot happen legitimately. One example that comes to my mind right now is a very hot example. The US Department of Treasury has a very recent, in March 2024, found some Iranian companies to be engaged in money laundering via some Dubai-based entities. And they procured some sanctioned technology of the Americans illegally. That was also done through money laundering. I think if you guys want, I can send you the link of the Treasury, the press note of the Treasury of US, United States. You can go through that. Another, I believe you've all heard of those Panama Papers. Has anybody heard of that?
Yes, we did.
Panama Papers is a classic example of money laundering. What happened is Panama Papers, money routed through Panama, tax evaded, money routed through Africa, tax evaded, went through a shell of companies in Panama, and this shell then introduced it, recharacterized the money and introduced it in another certain format so that taxes or the character of the money might be evaded. By character, I mean it might be money from kickbacks, which needed to be legitimized and introduced into the system. So that was one example, Panama Papers. And then there was this uh, Brazilian whitewashing scandal, car washing scandal. I think it must be interesting if you can go through the internet. The Brazilian car washing scandal. People also used car washing for generating illegal funds, So yeah, but at the end of the day, these things stifle your economy, stifle the legitimate people who want to work. So the Indian diaspora, they introduced something called a PMLA. Now, PMLA, by its very nature, is a very harsh piece of legislation. It's not something of a white collar legislation such as the Income Tax Act or the GST Act. Why I call it Income Tax Act as a white collar legislation is Income Tax Act has a lot of checks and balances, and you can have a lot of uh, black robes in courts going here and there, fighting nook and corners. And while the authorities, they need to give plausible examples, so a lot of things happen, but at the end of the day it is nothing of a blue collared law कि ईडी वाले आके आपको थप्पड़ मार के आपको जो भी है मुंह से निकलवा लेंगे, आपका ईडी वालों का मन हो गया तो मतलब अटैच कर देंगे आपके असेट्स. आई मीन इनकम टैक्स इज अ वेरी डिफरेंट वाइट कॉलर्ड लॉ एंड पीएमएलए इज अ ब्लू कॉलर्ड लॉ. It's very harsh. Penalties, PMLA is very tough. Section 4, and there's Section 4 says that you can be imprisoned if found violating, and for any scheduled offense. A scheduled offense is something that is defined in Section 2Y of the PMLA. Crucial tool is the power to confiscate assets, Section 5 and Section 8. Very wide powers, PMLA authorities on suspicion can confiscate the assets prima facie even before starting the proceedings. They have a preemptive power to attach the assets so that, just say the control of the assets does not go, the source of the funds or whatever it is, the resultant of the funds, they do not lose control over it. And PMLA has special courts, which is like Section 40. We have these appellate authorities in Income Tax Act, the Commissioner of Income Tax Appeals. It is the Commissioner of Income Tax for Review 264. Then we have the ITA. Likewise, there are special courts in PMLA. Of course, these are subject to constitutional review by the High Courts and the Supreme Court, but they have their own different mechanisms. Generally, the onus in case of income tax cases is on the department to prove that money has escaped assessment or whatever, But there is no reverse implication. That means the onus is not on the person to prove that it has escaped. The initial inquiry के स्टेज में डिपार्टमेंट को बताना पड़ता है कि ये हुआ है. PMLA में it is a suspicion and it is the own suspicion का notice आ जाता है आपके पास, then the onus is on you to prove it. So it's a very radically different system. And although international cooperation is there in tax also, but this is a different sort of international cooperation and it operates on a radically different level. इनकम टैक्स में इट्स अ वाइट कॉलर कॉपरेशन, जाके बैठते हैं टेबल पे बैठ के नेगोशिएट करते हैं, बातें करते हैं, पेपर्स एक्सचेंज होते हैं, लाइक लॉट ऑफ स्टफ इज देयर, बट दिस इज रेडिकली डिफरेंट. द मूवमेंट इज वेरी स्विफ्ट एंड इट्स नॉट लाइक कि साल में एक बार मूवमेंट होता है. एंड let's face it, all the jurisdictions are very, very, very strict right now on money laundering, especially after this Chinese episode with Taiwan, the Iran episode with America, and the Russian-Ukrainian scene. Everybody is very, very tough on money laundering. So this is an idea of how the PMLA disrupts. Penalties are tough. Confiscation is very easy as compared to any other law. Courts are special, so yes, they have the special focus. They do not have a generic focus, and obviously cooperation is there. Income Tax Act, as I mentioned in the earlier slide, So the primary focus is on the origin and nature of income, not funds, income, aiming to ensure that all taxable income, irrespective of its source, is duly reported and taxed accordingly. 259 sections 443, 44, all those are there to bring your income into the taxable ambit. Penalties are there, 271, 274, 271A, basically penalties under 274 and red bit sections. Non-payment provisions are strict, 276C, but 276C को enforce करने के लिए भी there are a lot of mechanisms which you have to go. The file has to generally go through the TRO, and then a lot of things happen, recovery. And generally 276C का इतना जल्दी use नहीं होता है. But it is there, but not as, like radically as easily as the PMLA. Now, by enforcing tax compliance and penalizing evasion, the ITA acts as a deterrent against generation of black money. It is a deterrent, but how effective it is, I guess we are all aware of it. 1961 से अभी तक इनकम टैक्स एक्ट से तो deterrent ज्यादा कुछ आया नहीं. Whether we speak of NBFCs or capital gains या जो भी है, जिस भी तरीके से money has been painted from black to white, it's always there. It's always there. Anything in mind? Anything anybody wants to ask me? Hello.
I think we can have question answers in the end. Maybe you can
Okay.
complete your. Yeah.
Okay. So a combination of PMLA and ITA is a very, very powerful, a blue collar and white collar approach both. The focus is definitely radically different. So the PMLA is designed to disrupt the process by which criminals attempt to make the illegally obtained money appear legitimate. It escapes, sometimes it is becomes, but it is there. The most famous case is the Nirav Modi case, जहाँ बैंक PNB में उन्होंने रूटिंग की थी अपने स्टॉक्स की, and they got LCs, SBLCs without having actual funds, and they laundered the money all around the globe. फिर उनके assets seized हुए. So that was a very famous case, Nirav Modi case. You must be aware of it. इनकम टैक्स एक्ट में हसन अली खान वाला केस, आई थिंक उस पर वेब सीरीज भी बनी थी शायद. इट वाज द स्टैम्प पेपर स्कैंडल. तो उनको इनकम टैक्स ने नैब किया था, एंड दे क्रैक डाउन एंड kill this entire network of forging stamp papers. It's a very interesting case. I would recommend you read this Hassan Ali Khan case, and you might also watch the web series if you want. It's a different angle, but you'll get to know what it is there. So the impact is obviously combating black money. By working in tandem, the PMLA and ITA create a formidable barrier against black money. Vijay Mallya case exemplifies the synergy. Vijay Mallya case is very famous. I mean, I really don't need to explain on that. Everybody knows about it. आई मीन उसमें तो सब कुछ हो चुका है, उसमें कुछ बाकी भी नहीं था. मनी लॉन्ड्रिंग था, टैक्स इवेजन था, क्या नहीं था उसमें, सब कुछ था उसमें. सो शारदा वाला केस, आई थिंक पीपल फ्रॉम बंगाल वुड बी मोर अवेयर ऑफ शारदा, आई गेस. बट आई थिंक इसका पब्लिसिटी ऑल ओवर इंडिया हुआ ही था. तो शारदा केस वॉज ए चिट फंड. They took money promising very excessive returns, 30%, 40%, and सारा पैसा गायब. एंड फिर वो इन्वेस्टिगेशन चला, ईडी ने रेड्स किए, कुछ किए. द प्रोसेस इज गोइंग ऑन. बट यस, पीएमएलए में असेट्स को सीज कर लिया. असेट्स को सीज करके एटलीस्ट those assets are not being used by those launderers and everything. At least they're under the control of the government for the time being, at least. So the focus and targets of PMLA and ITA. PMLA, the focus is it stops criminals from hiding illegal money, and ITA says pay your taxes. Targets are placement, layering, integration of dirty money into the system. And for ITA, it is tax evasion and undisclosed income. To be very honest, I think there was an amendment in 2016 when there was a demonetization. So the earlier section 68 undisclosed unsubstantiated income and everything, 68, 69, 69C, 69A, everything used to be 30%, the highest tax slab rate. Subsequently, after enduring demo, it was changed to 75% plus 25%, which was legitimately on a very high level. Again, the interesting fact I would like to, before we go to the next slide, is can we think of a situation in which money is laundered and taxes are paid on the laundered money? Does that become legitimate? That is a very interesting question. It becomes tax legitimate, but does it absolve you of PMLA? It does not. एंड मान लो कि टैक्स ने प्रोसीडिंग स्टार्ट कर दी, इनकम टैक्स ने बोला कि ये लेजिटिमेट मनी है, वी आर गोइंग फॉर असेसमेंट प्रोसीडिंग्स, सो in that case, are you absolved of the PMLA? Which is a concept we'll go on in the next slide. There's a concept called double jeopardy, which is a constitutional concept. We will not be going into constitutional law as such, but we will be sticking to double jeopardy in the context of PMLA and ITA only. So double jeopardy is if you have committed an offense, then you should not be punished twice for it. One offense, one punishment. Article 20 bracket 2 of the Indian Constitution. So well-established doctrine of double jeopardy under Article 22 of the Constitution of India serves as a vital safeguard against the impermissible imposition of multiple punishments for a singular offense. Now, the quandary is, does it apply in the case of black money laundered and taxes paid, thereby showing legitimacy? No. No. So, even if you pay taxes on that, आपके ऊपर PMLA लगेगा. Just because you pay taxes on a money which has been laundered does not absolve you of PMLA. या फिर डिपार्टमेंट टैक्स लगा दी, पेनल्टी लगा दी, एंड इफ यू गोइंग टू कोर्ट टू क्लेम कि भाई हमने टैक्स और पेनल्टी, हमारे तो पनिशमेंट हो गई है, हमने तो पेनल्टी भी पेमेंट कर दिया है, नाउ वन पेनल्टी, माय पनिशमेंट इज ओवर. सो दैट डज नॉट हैपन. The protection of double jeopardy is not available in the case of PMLA and ITA. P. Chidambaram's case is something you might want to refer. There's another case which we're going to discuss some slides down the line. Janta Jha versus Assistant Director. It's a Odisha High Court case, and it has been appealed in the Supreme Court, which is the natural course of things. But definitely, अभी जो situation है, court की जो leaning है towards the administration, I think, I mean, I won't be biased when I say administration. It is the right thing to do. So I think that judgment will be upheld. So coming back, navigating the overlap. Double jeopardy is a fundamental right protecting against multiple punishments of the same crime. Article 22 PMLA can target, and ITA can both target illicit funds. Potential double jeopardy conflicts exist. I say there are conflicts, but there are also case laws saying that no, in case of money laundering, the very fact that you paid penalties in the Income Tax Act and you've been punished for that does not absolve you from the vagaries of the PMLA. This case law will continue to evolve, and so we'll see. Financial crimes, taxes. There was a case, very famous case in the US in the early 30s, and it was Al Capone बोल के एक गैंगस्टर था. तो भाई साहब को कोई तरीके से पकड़ तो नहीं पा रहे थे, उनको इनकम टैक्स लॉ में पकड़ा गया था, एंड देन दे वर पनिश्ड अंडर दैट लॉ इन द यूएस. तो वैसे है, अभी तक इंडिया में तो आए नहीं है, बट होपफुली देयर विल बी केसेस लाइक दैट वेरी सून इन इंडिया आल्सो. Coming back to Janta Jha, this is a very famous case, and I think all practitioners or general people should be aware of it. Janta Jha is a Odisha High Court case, and the numbers are written out there. Petitioners contended, now this is very important, please. Contended that the PMLA proceedings constitute a violation of the protection against double jeopardy. This argument rested on the premise that the income in question had already been subjected to scrutiny and potential penalties, the exact things that we were discussing 2 minutes ago. Under the Income Tax Act, rendering the PMLA action duplicative is the keyword, potentially punitive is the keyword for the same underlying conduct or the same predicate offense. The keyword is predicate offense or underlying conduct. So the Odisha High Court upheld the principle of generally specialibus non-derogant. That means a specific law will override a generic law. Very interestingly, the Odisha High Court has opined that the Income Tax Act is a generic law, it is not a specific law. So coming back, Para 12, considering the facts of the present case and the provision of the PMLA as amended by 2013 amendment, this court is of the view that the PMLA being a special statute, it has an overriding effect on the Income Tax Act. The court is of the opinion that the Income Tax Act is a generic act, is a generic law. And further, considering the huge amounts of money, yes, this is also another factor, which are lying in the bank accounts of the petitioners as well as the nature of the proceedings under the PMLA. More specifically, Section 24, very important section, we'll come to that later on, which provides, with regards to burden of proof, the thing that we said, the onus is on the person receiving the notice. So the administration does not have to engage in anything. It is on the onus, the person receiving the notice, on whom the onus is to prove that he is innocent. So the maxim of innocent until proven guilty does not apply in PMLA proceedings, and which is very, very important for the general public to know also. The legal principle, the criminal law principle, the of innocent until proven guilty does not apply in PMLA proceedings, and that itself gives the enforcement directorate lot of wide powers. Anyway, coming back, Section 24, which provides with regard to the burden of proof that when a person is accused of having committed offense under Section 3, the burden of proving that the proceeds of crime are untainted property shall be on the accused. The court is of the view that even if the petition number 2 has been acquitted of charges framed against him in the sessions trial, proceedings under the PMLA 2002 cannot amount to double jeopardy. A proceeding under the PMLA 2002 cannot amount to double jeopardy, where the procedure and nature of proof are totally different from a criminal proceeding under the Indian Penal Code. So, I believe as income tax practitioners, we are well aware of the fact that officers under the Income Tax Act are vested with the powers of a magistrate under the Code of Criminal Procedures and the judge under the Code of Civil Procedure. This case of PMLA is radically different from that. So, PMLA focuses on the act of cleaning dirty money, targets the process, not necessarily the original crime that generated the money. If you remember Section 3, when we discussed in an earlier slide, so placement, layering, and integration. So placement of the money, layering of the money via different tranches, or via different stages, via different legs, and making it impossible to trace back, and integration of the money into the legitimate system. So this entire 3 stages are targeted in a PMLA, and God forbid if you're involved in any, be ready to face the consequences. By the way, and this another point I would like to bring in. Cryptocurrency is a very new fact that is going on, and taxation of cryptocurrency is something out there. PMLA as such does not have cryptocurrency embedded in its framework. However, it has digital records embedded in its framework. So how is that going to help? How is the case law going to evolve on cryptocurrency is something that we need to see going ahead. Even in the case of Income Tax Act, if fair reporting is not done, and given that cryptocurrency is untraceable, case law is going to evolve, and that is some area that we need to see ongoing in the future. Income tax focusing on tax compliance. Uh, the ITA delves into the origin of the income to determine its tax liability, categorizes income into different heads: salary, business, capital gains, other sources, etc., and prescribes rules. For salary, we have different rules. Business, then we have another area completely. Then we have capital gains, which are different types of capital gains for different indexation, non-indexation, 115, all the stuff is there. Prescribes rules for this thing. And very, very interestingly, the law says that even illegal money is taxable. Illegal income is taxable. So while the PMLA says that the act itself of layering introduction is an offense, the Income Tax Act says even illegal money obtained via that way is taxable. Case in point is Bahadur Kamak Narayan Singh versus Commissioner of Income Tax. Then CIT versus K. Tangamani, Madras High Court. Income from illegal activities is taxable. Just because you're paying taxes does not mean that your income is legitimate. Your money is not income. Money is legitimate. Your taxes is something that you owe from the income. But the legitimacy of money is not in the domain of the Income Tax Act. The legitimacy of the money is exclusively the domain of the PMLA or the Black Money Act, which is a different area of discussion. But yes, the legitimacy is there, the question. So the crucial distinction is there is overlap. PMLA is crime is laundering process itself, a crude product, which is why I say blue collar product. And ITA crime could be tax evasion, and in the end result, a sophisticated product. आपको इनकम टैक्स वाले आएंगे, डिमांड बना देंगे, आप डिमांड को दर्ज दोगे। ईडी वालों की तरह नहीं आता है कि आएंगे यार, धमकाएंगे यार, हो सका तो दो चार इधर उधर लगा भी देंगे यार, उसके बाद आप कुछ करोगे नहीं करोगे, पहले तो आपका एसेट से अटैच कर देंगे, उसके बाद आप भागते रहो इधर उधर इधर उधर। इनफैक्ट हम लोग की यही डिस्कशन हो रही थी, एंड देयर वाज ए notification in July 2023 wherein अगर इनकम टैक्स के पास कोई इंफॉर्मेशन है तो there was it used to be earlier कि there were certain legal procedures to be followed while that information you used to constitute information for the enforcement directorate to act on. So there was a notification in July 2023. I don't remember the number right now, but now the very fact that the department issues a notice is sufficient information for the ED to act on. So that is a very interesting part of it. Inconsistent frameworks, PMLA aims to, they both aim to combat financial crimes, but their rules are very inconsistent, and we'll go to that. We'll go to in the next stage. Now, because the rules are inconsistent, especially with regard to asset attachment, evidence collection, disposition before authorities, the application of the same is also radically different. So we'll get to it in the next stage. This is very, very important. So PMLA, okay, PMLA has, if the authorities have reason to believe that the assets are linked to crime, I'm telling you, mere reason to believe, they can attach the assets. Correspondingly, Income Tax Act में you have to have a lot of reason. You have to give a lot of reason. Either the proceeding must be over and you're not paying taxes, or in case there's a preliminary attachment 281, I think ASC or something like that, it is 281 something. There can be a provisional attachment, but the provisional attachment has to be made after satisfying a lot of complexities. A lot of procedures are there. अप्रूवल भी लेने पड़ते हैं हायर अथॉरिटीज के. पीएमएलए में भाई साहब आपको कुछ नहीं करना है. यू हैव रीजन टू बिलीव, यू हैव समथिंग ऑफ अ रीजन टू बिलीव. आप एक बार तो अटैच कर दो, बाद में वो लोग छुड़ाते रहेंगे. बिकॉज एक बार तो रीजन टू बिलीव है, फिर आप हाई कोर्ट जाओ, सुप्रीम कोर्ट जाओ, आप छुड़ाते रहो. सो दैट इज अ वेरी डेंजरस एरिया. बोला जाता है कि पीएमएलए में पावर्स आर वाइड इनफ. Abhishek Manu Singhvi is arguing in the Supreme Court for a lot of cases कि this PMLA power should be curtailed, and Tushar Mehta is no, should not be curtailed. This is a draconian law that needs to bring civility into this anarchical society that we have right now. I'm sorry for using these words, but right now we are operating in a sort of anarchical society. So, asset attachment is possible during the early stages. Accused carries the burden of proving the assets are legitimate. If you receive the notice, it is incumbent upon you to prove that the assets are legitimate. The department just needs to have a reason to believe, not even, a concrete reason, just a reason to believe that the assets are legitimate. They do not need to evidence it. They do not need to prove that there has to be um, there has to be some evidence linking to the illegitimacy of the assets. No, they do not need to have evidence, just a reason to believe. And for that reason to believe, any complaint by any Tom, Dick, and Harry is sufficient. ITA requires a higher burden of proof, as we were discussing. Even with best judgment assessments, the burden remains on the authorities. In case best judgment is generally 144 or 144C, when the assessee repeatedly fails to reply to either notice for inquiry 142.1 or show cause or anything, then the officer is constrained, and even then in the 144 order he has to actually specifically write that we had served these notice on these days. So the burden remains on the authorities. In the Income Tax Act, safeguards are built into the system. So even if you're passing any order, अभी तो वो 148 A का और 148 A D A B confusion चल रहा है. एंड अभी तो बॉम्बे हाई कोर्ट ने एक नया कंफ्यूजन और क्रिएट कर दिया. बट दैट अपार्ट 151 का अप्रूवल आपको जरूरत है. आपका अगर लेजिटिमेट अप्रूवल नहीं है 151 का, सो यू कैन नॉट इवन हैव अ 148D ऑर्डर. तो and 148B notice for that matter. So a higher burden of proof is there in ITA as opposed to the PMLA. Contradictory outcomes. An asset could be seized under PMLA due to suspicion alone, reason to believe. That's it. Thank you. However, the same asset might escape scrutiny under the ITA because of the higher evidence standard. This highlights the contrasting approaches. PMLA focuses on validating the legality of the asset itself, while the ITA prioritizes identifying the revenue source behind the asset. Inconsistency weakens the effort. Disparate investigative powers. Now, PMLA officers wield broad, extensive powers, and they can act very, very swiftly with minimum judicial oversight. Okay, the only thing is reason to believe. That's it. So their action will be very swift. They do not have to go to authorities. They do not have to seek approval. They don't have to seek anything, any reason to believe, and they can make an action. Okay. Critics argue that these broad powers can be misused and they infringe on individual liberties. And now this is a broad question, which again is being argued by Abhishek Manu Singhvi in the Supreme Court. Income tax authorities, on the other hand, generally require court approval before undertaking similar actions. Even अगर सर्च भी करना है 132 में, independently नहीं सर्च कर सकते, approval आपको लेना ही है. This adherence to stricter warrant procedures ensures a level of judicial scrutiny, protects citizens from unwarranted searches and seizures. However, the warrant requirement can reduce delays in investigations, unless and until, of course, the information is very, very concrete. There might be some delays, so potentially allowing criminals to move or hide assets before authorities can intervene. M. Shobna versus Assistant Director. This is a case law. The case exemplifies the potential for conflict arising from the PMLA's broad scope and the ITA's scope on tax evasion. Petitioners were accused of real estate fraud. Okay. And they said कि predicate offense हमको cheating का under the IPC it was there and it wasn't directly related to tax evasion. They contended that the PMLA should be reserved for more serious offenses. हमने सिर्फ cheating की है, PMLA हम पे क्यों लगा रहे हो? So court said no, thank you. PMLA आप पे लगेगा because at the end of the day you have been involved in layering and you have been involved in introducing illegitimate money into the society back. So, court decision in M. Sopna highlights the potential for the PMLA to be applied in situations that extend beyond traditional tax crimes. It underscores the importance of ensuring a clear division of responsibility between the EDA and the Income Tax Department to avoid duplicative investigations and to streamline the process for individual business caught in the crosshairs of financial crime inquiries. This is one case I would suggest everybody read. इसका एक बार ऑर्डर आ चुका है, फिर अभी आई थिंक अक्टूबर 2022 या 23 नहीं 2000 नहीं आई थिंक 2022 में इसका ऑर्डर आया हुआ है, but there is again application after application for review of this order. So right now I believe the last hearing was in March 24 and there's a subsequent hearing date set in July. This is one of the landmark cases as far as money laundering is concerned. So, while the judgment in Vijay Madanlal Chaudhary was significantly under consideration for review, may see further development, it deserves consideration for its potential impact on the interplay between the PMLA and the ITA. Although the case did not directly address the ITA, its ruling on the reverse burden of proof could shape how litigants substantiate the legitimacy of their income when confronted with inquiries with both ED and the Income Tax Department. Supreme Court observed in para 102 B, it noted that the presumption under Section 24B, Section 24 is a very important section. So 24B of the Act is not a mandatory legal presumption, unlike the case falling under the other category. If the person has not been charged with the offense of money laundering, the legal presumption that 24B can be invoked by the authority or the court as the case may be. More or less same logic as has been noted while dealing with the efficacy of Section 24A would apply. I'll read 24A and 24B again when we end this presentation. I have it open so that things will be more clear. Slide 22. Collection of evidence. This is really important. Enforcement has broad powers. We've already discussed Section 5, Section 3, 24, 17, 18. Okay, 17 is reason to believe जाके सीज कर लो, काम खत्म. 18 reason to believe आदमी को उठा के लेके आ जाओ, बैठाओ उसको ऑफिस में, and that's it. And 5 नोटिस भेज दो. 3 नोटिस भेज दो, सामने वाले को प्रूव करना है कि he is innocent. So the powers are wide, but at the same time, because these powers are wide, people are actually wary of them and the proceedings happen quickly. Statements. This is very important. I think we're all aware of the fact that statements made before the police or any person who is not vested with the power of a magistrate under the IPC or a civil judge under the CPC, any statement made is inadmissible as evidence. However, very interestingly, Income Tax Act mein all the authorities, including the income tax officer, the assistant commissioner, the joint commissioner, additional commissioner, principal CIT, chief CIT, PCCIT, they are all vested with the powers of a court under the IPC and as a judge under the CPC to administer oath and take evidence. Likewise, as opposed to the police, as opposed to the customs department, statements to the ED under PMLA are evidence. So अगर ऑफिसर खराब हाथ में पड़ गया, प्रेशर मार के कुछ स्टेटमेंट निकाल लिया, वो जो स्टेटमेंट है दैट इज कंप्लीटली एडमिसिबल एंड दैट्स इट. इट इज नॉट लाइक कि आपने पुलिस वाले को बोला एंड इट्स नॉट एडमिसिबल. इट इज एडमिसिबल. There are two cases, Tufan Singh and Selvi. I'll discuss them with respect to self-incrimination. The protection against self-incrimination applies even under Section 24. So yes, checks and balances are there, but they are admissible. Extensive powers to investigate money laundering. Section 17 empowers the ED to conduct searches of premises, seize assets believed to be proceeds of crime, believed to be, reason to believe, not proved to be assets of crime. Okay, believed to be. Examine various forms of digital records, including financial transactions, communications, and other data stored electronically. This allows investigators to gather crucial evidence and trace complex financial trails across digital platforms. Section 50, power to summon and record statements, जो मैंने आपको बोला अभी, summons में आप आए तो ठीक है. Very interestingly, I think there was a case decided, I think about 3 या 4 दिन पहले ही अभी हुआ था कि अगर आप अपियर कर जाते हो तो वो अनलेस एंड अनटिल विदाउट कोर्ट के परमिशन को ईडी आपको पीएमएलए में अरेस्ट नहीं कर सकती है. ये अभी 3-4 दिन पहले ही था केस. I'll share the case law if you're interested. I'll share that. Tufan Singh versus State of Tamil Nadu. This is a very interesting case. Use of statements admissible under certain conditions. Strict procedures must be followed, including recording with legal representation if the other party so desires. Accused must be made fully aware of the rights before recording such statements. Although this is paper, because सामने में जब ऑफिसर बैठा रहता है तो वो राइट्स वाइट सबको मालूम होता है वो क्या होता है. तो Selvi versus State of Karnataka. Independent corroborating evidence balances anti-money laundering efforts with individual rights. This is a very interesting case law, but kitna the this thing, this is not exactly a PMLA case law, but individual rights का case law है. कितना hold करेगा, that is now again subject to arguments in the Supreme Court. Investigative powers 133A survey है, seizure है 132 में. They can call for evidence under 131. They can call for information under 133(6). This is out there. So there's a balance, and we're very well aware of this. ठीक है ना? Search and seizure operations, again, they're basically made out of warrants, higher authorities of warrantly and currently and all those there. But in the Income Tax Act, there's a lot of safeguards of the assessee's rights, the person being searched upon. There is a very interesting part. Data sharing. When I say PMLA is something कि information radically बहुत easily share होती है between departments. So the Prashant Jha that I was speaking of, he's the director of Central Information Exchange, operates under the Ministry of Finance. So FIU is a part of his job. Now, so FIU क्या करता है? फाइनेंशियल इंटेलिजेंस यूनिट्स इधर से इंफॉर्मेशन उधर शेयर करना, उधर से इंफॉर्मेशन इधर शेयर करना. SAR जो है सेक्शन 12 में है, PMLA में सस्पिशियस एक्टिविटी रिपोर्ट बनती हैं. सो लॉट ऑफ इंटेलिजेंस शेयरिंग इज देयर. ओके, इंफॉर्मेशन एनालाइज टू आइडेंटिफाई पैटर्न्स, रेड फ्लैग्स, if any suspicious activities declared and stuff. ITD, ED, NIA किसी को भी देना है, FIU इंडिया शेयर करती है. Financial Intelligence Unit. There's a website. If you want, I can share the website out there. Section 66, information sharing. So your information is not protected under both the PMLA and the ITA. no protection of your information is there. If it is there, it will be shared. Full stop. आप ये नहीं बोल सकते हो कि my information rights are there or something. No, there's nothing. There's no right to privacy. There's no fundamental right to privacy under PMLA. No fundamental right to privacy under Income Tax Act. So that can be shared very, very easily. So the director, section 66 of the PMLA explicitly authorizes the sharing of information. Director of FIU is vested with broad powers, enables seamless exchange of financial information with the other departments. Such collaboration is definitely aimed at fostering a targeted approach towards organized crime, especially financial white collar crime. ITA is under section 138, and likewise डिपार्टमेंट शेयर करता है, FIU को भी करता है, अदर डिपार्टमेंट्स को भी करता है. So those things happen, you know. This in a nutshell was a discussion that we had, and what I'm sharing with you right now. I would be happy to take on some questions, although I will admit that I'm not the best resource, but I will try my best to give you some answers out there. Varsha ji?
Thank you so much for giving us such information, vast information. Now we are open for question answers. If anybody has any questions, you can just raise your hand and ask the question.
सब थक गए होंगे वैसे भी.
No, the topic was so intense that to
हेवी है,
grasp it
एक्चुअली हेवी है, एक्चुअली
and
काफी
लेके
है.
जाना, यह काफी है.
मैं काम कर सकता हूँ. इनफैक्ट यू नो, इफ पीपल आर इंटरेस्टेड, अगर अपने पास ईमेल्स का कोई लिस्ट है या ऐसा कुछ है, व्हाट वी कैन डू इज वी कैन शेयर दिस प्रेजेंटेशन, वी कैन शेयर माय आर्टिकल्स, एंड देन वी कैन शेयर some of the case laws that I've discussed, so that you know, if anything comes to their mind or something, they can very readily share their questions, and then we can take it up.
Yeah, sure, we can do that. We have the database of members, especially the finance professionals. Now we have formed their group also, finance and legal. So maybe we can share all this information there. So we don't have many questions as of now, but your session was fantabulous. It was mind-boggling. And I can invite Narendra Ji Navlakha to say vote of thanks. He's there with us today. Narendra Ji? Narendra Bhaiya? Are you there online?
I think there's some communication out there.
Hello.
Hello.
Yes, Narendra ji.
Yeah, I am on the line.
Yes. कैमरा ऑन करिए भैया. Hello.
So is it visible?
Yeah, audible and visible both. Yes.
Okay. सभी को जय जिनेंद्र, जय गुरु राम. A very useful insight presented by Mr. Piyush Baid. Thank you very much. साधु मार्गी प्रोफेशनल फोरम की तरफ से पीयूष जी को बहुत बहुत साधुवाद, और आशा करते हैं कि आगे भी वो ऐसी इनपुट्स वगैरह लेके आए और हमको इतनी जानकारी से अवगत कराए. थैंक यू वेरी मच.
Thank you, Ramesh ji. Thank you.
Yeah. So Piyush ji, this was thank you Narendra भैया. नरेंद्र भैया बहुत कम आते हैं हमारे फोरम पे on camera. So Narendra भैया, thank you very much. And Piyush ji, your session was just mind-boggling and very insightful. Now हम लोग आज का सेशन एंड करेंगे संघ समर्पणा की 2 पंक्तियों से. So I would like to invite Sambhavji Loda, Dr. Sambhavji Loda.
जय जिनेंद्र जय गुरु राम। संग समर्पणा गीत। संग हमारा अविचल मंगल, नंदन वन का महक रहा, हम सब इसके फूल व कलियां, सुंदरता निज संग आहा। जय
जय जिनेंद्र, जय गुरु नाम, जय गुरु राणा, जय गुरु राम सभी को। Thank you so much for joining on this Saturday evening for another session of SPF. Thank you so much.
Let's
Jai
connect.
Jinesh and Jai Guru Ram. Thank you, Piyush ji, everybody,
Thank
for
you so
joining.
much. Thank you, everybody. Thank you for your time.
Yeah, thank you.